Okay, today is February 8th, 2012. This is Children and Justice. We're right smack in the middle of learning Module 2. And when we left last week, I was emphasizing the skepticism generally in America and in the legal system as well. And that's what's most disheartening, that throughout the ages and throughout recent history, the legal system has also been highly skeptical of women and kids and of sexual abuse allegations and sexual assault allegations. And I think as I was leaving, I was mentioning that case where a drunken woman who was a Gap executive who had just been transferred to San Francisco was so intoxicated that the cab driver felt bad for her and called 911. They gave the cab driver a little bit of a hard time, but eventually 2 police officers were dispatched. They escorted her to her apartment, and one of them wound up having sexual relations with her, claiming he never had sexual relations with her. She reported that she was sexually assaulted. In any event, he was acquitted, and the lookout, who was his partner, I believe he was acquitted as well. They may have been found guilty of minor charges, but the most important charge, the sexual assault, they were found not guilty of. That was one case where the public reacted, I thought, appropriately. The public was outraged by the acquittals. Most of the time, the public isn't outraged by the acquittals. They agree with them. Most of the time, the public sees it the way the jury saw it and the way the defense lawyers presented, as some woman who was spurned or some child who wanted to get back at dad or stepfather or uncle for some slight or some punishment that they received. So they made up this rather just difficult to think about, much less to testify about or to tell police officers about, false allegation. Most of the time, jurors and average people are only too willing to embrace these defenses and these statements by the accused. In this case, they were outraged, and there were some protests in New York, and there were some public statements made. And I think it's because the evidence really was overwhelming. I really felt as this case was unfolding, and I'll send you the link, I'll post it on the announcement page, or put it in the Cyber Cafe, a couple of links, but it really felt as it was unfolding that these guys were going down. And if you were going to win an acquaintance rape case, this isn't even an acquaintance rape case, but if you're going to win an intoxicated victim case, and that's what this was the case that the prosecution would win. And I told you last week that the defense, why he ever said this, why he took the stand, I'll never know. If I was a defense lawyer, I wouldn't have let him take the stand. But, hey, it was successful. Sometimes the wrong decisions are successful and that people think they're the right decisions. Just because a bad decision works doesn't mean it's the right decision. Anyway, he took the stand, and I think I told you that he testified that she was naked from the waist down, wearing only her bra, and he was in his full uniform, and he decided that because she was drinking and he's a former alcoholic, he would talk to her and lecture her and educate her about the perils of drinking. And I guess because, I'm not sure why, I can make a million jokes, but he found it necessary to crawl into bed with her and spoon with her in uniform while she was naked from the waist down, wearing only her bra, and then tell her about the evils of drinking. How the jury let this guy go, I'll never know. In fact, one of the things they did was, among other things, there were all little layers of evidence that really pointed to that these guys wanted to take advantage of a drunk and attractive woman laying in the back of a cab. But one of the things they did that was most startling and most interesting was there was a phone call made to 911. And it was designed, so the prosecution argued, and it seemed to be rather transparent, it was designed for them to go back to the scene of the crime. Now, there was testimony that maybe he left a cigarette lighter there, or his gun, bullets, or he left something important there, one of the guys, at the scene. So a man claiming to be a neighbor of the victim, I'll call her, the victim in my mind, a neighbor of the victim called up to say there was a drunken, smelly guy in the hallway and they needed the police to respond. And the dispatcher gives that caller a hard time, and he claims he's a foreigner, And they say, well, where are you from? He says, Canada. And he had a very distinct Brooklyn accent. He wasn't from French Canada or Canada in the least bit. It was almost silly, the suggestion that he was from French Canada or was French speaking in Canada or a foreigner at all, when it was obvious he was some New Yorker. Yeah, there's a smelly guy outside the apartment. I need to. So, well, that sounds kind of Bostonian, but in any event. So finally they go, all right, we'll send a car there. And one of the cars, this is broadcast over all the police radios, and one of the cars says, it's Del Russo and Jones. We're right near West 4th Street in the Village. We'll go there. No, we'll go there. Well, where are you? We're on the Upper East Side, but we'll get there. Don't worry about it. We'll get there, which is 57 blocks away. They were very far away. There was another car right in the vicinity of the so-called smelly guy laying in the hallway at the same apartment where the victim lived. Yet they said, don't worry about it, Del Russo, we'll go. All right, go ahead. You guys want to come from 20 blocks away to report to the scene? Go ahead. And they drove away. Those officers were only too happy to not have to do any work, and they drove in the other direction. That was obviously part of what happened here, and obviously part of the cover-up when they went back there. And they did one other thing that was pretty bizarre. I forget what it was. I'll have to look it up. That was really transparent and made it clear that this was a rape and a molesting. But, the point of it is, despite all that evidence, and I have it all chronicled somewhere, the jury still felt that there wasn't enough there. We don't know what really happened in that room. We believed her. These are some of the quotes. We believed her 100%. But we really don't know what happened in that room. Well, your job is not to know what happened in the room. No one knows what happened in the room except those two. And one of them was intoxicated and unconscious, and the other one's got a Fifth Amendment right. All you need to do is find out if beyond a reasonable doubt she gave her free and affirmative permission. And that's in New Jersey. In New York is a little bit different. Nevertheless, you can't have sex with unconscious women, even in New York. So they're acquitted. Now, today's Post, Times, Daily News has, and I told you we saw this coming last week, and maybe appropriately so. I don't know enough of the facts. But the commissioner's son, who's the co-host of Good Day New York, I think his name's Kelly. What's his name? Rob Kelly. Rob Kelly took a leave of absence because he may have met a woman at South Street Beach, Shreveport, and wound up at her paralegal office because she's a paralegal and they had sex. And she says it was coerced and forced. He didn't say anything, as is his right. And they investigated, and the case was conflicted because he's the son of Raymond Kelly, the police commissioner. So the district attorney for the city of New York did the investigation. And today, the letter came from the DA, Cyrus Vance, who said there's not enough evidence. Matter of fact, he said something different. I typically say there's not enough evidence if I have to make a public pronouncement on what the outcome of the investigation is. I avoid that at all costs. I don't know what happened, ever. And I don't want to be into speculating about what happened business. As a professional, as a prosecutor, when I have to go to a jury trial, I tell them I proved the case beyond a reasonable doubt. Here's why, and I'm confident of that. And I tell them that as effectively and persuasively as I can. But Cyrus Vance said this wasn't a crime, which was interesting. Now, they may do that all the time. I don't know what their protocol is for issuing a letter. I am prone to say there was insufficient evidence to prove this case, therefore the investigation is closed. He said, or his subordinate said, we've investigated this case, and the victim's allegations are not criminal. What happened here was not criminal. Words to that effect. It's reproduced in the New York Post today, the letter, and the Daily News. What happened wasn't a crime. So the press says, well, are you going to prosecute her? And diplomatically and tactfully, Prosecutor Vance, I think, handled that appropriately. He said, look, from her perspective and her vantage point, she truly believes that she was exploited and taken advantage of and coerced. So we can't charge her either. And you're very rarely going to charge a victim or a woman who, or a child, or a man, but I'm talking about kind of stuff that we do, or that what I'm teaching you about, you're very rarely going to charge a woman or a child in a case where you can't prove it, or even when you're skeptical about its truthfulness or veracity. I don't know. I wasn't there. People react in a lot of different funky, weird ways when it comes to people molesting them or taking advantage of them, or when they get involved in situations with intimate partners. People do the oddest things, especially child abuse. We'll talk more about that later, and in forensic interviewing, we get into great detail about the psychology of sexual exploitation and incest and the like. So I don't presume to know what happened. I don't know what happened with the two cops and the drunken Gap executive. Okay, I don't know exactly what happened. But I know what she said, and what she said is highly persuasive and completely consistent with the facts. By the way, to his credit, Mayor Bloomberg and Ray Kelly immediately fired those two guys, the two police officers in I think it was the East Village, not the West Village, but whatever, the downtown Gap executive rape case. And they became despised among many, or by many. But in this case, the media brought up the issue, and I'm talking about the guy from Channel 5 News there, the Father Kelly case. In this case, they asked, "Are you going to prosecute the victim?" And the alleged victim, he says no. And that was a good way to put it. From her perspective, she felt coerced. And again, the reason I bring this up is this doesn't help, right? The history of skepticism about the claims of women and children is not helped by weak accusations, by weak, high-profile accusations, and by accusations that may be false. Like the Duke rape case a couple of years ago, 4 or 5 years ago. Dominic Strauss-Kahn, the IMF president, who happened to wake up one day, was packing his bags, and the chambermaid decided she wanted to perform fellatio on him as he was exiting. What a great day for Dominic Strauss-Kahn, the president of the International Monetary Fund. That's his position. That was his defense. I don't know. I never met her before, never saw her before. I was packing up, and before you know it, she wanted to perform oral sex on me. So I did, and I left. And then I had lunch with my daughter, who's going to NYU. Doesn't make any sense. But in any event, she had such a bad background, right? We talked about it last week. I mentioned it. Her history was so problematic and full of lies. And you're going nowhere fast if you have a history of lying, even if you're a victim, even if it's true. So that case, the Duke case, this case, going back to William Kennedy Smith in the 80s or 90s, whenever that happened, and there's many in between. You have these accusations that really feed this antiquated notion about how women make up allegations to get back at a guy, or because they're angry, or because they're out for vengeance, or they want to blackmail somebody, or they want to get somebody back. And then you have Brian Cashman, who's the general manager of the New York Yankees, who it seems has somebody who's mentally unstable stalking him. And it takes two to tango, right? I mean, from the news articles, and I don't know this woman, I don't know her background, but from the news articles, see, she's unstable. She has at least 4 men who have restraining orders against her. I mean, most of us get through life without ever having a restraining order against us, okay? So if you got 4 against you, I'm not saying you're a bad person, but you never know. That's a little suspicious. Or, never mind, they include her mother, her sister, and the ex-boyfriends. And now Brian Cashman. And it goes to show you the stupidity of some men. The guy's got all the money in the world, he's married, whatever. Is this who you connect with? Man. Anyway, so we talked about that, and the way that chapter ends, and I don't want to give it short shrift, I put it up here, is allegations of abuse that occur in the context of matrimonial actions. There's a perception that when mothers, typically mothers, let me put it more generically or more neutrally, there is the perception that when there is an allegation of child sexual abuse, or physical abuse, but most often sexual abuse, in the context of a matrimonial action, that it's probably false, that it's probably a lie, it's probably untrue, it's probably the work of the mother in most cases. And that is a dicey area of child protection and a dicey area of criminal prosecution. And the concern there is, among well-meaning people, that because the mother in most cases is not being heard or being listened to or not winning or not getting what she wants in the family court, or she's not getting custody like she wanted to get custody, or not getting terms that are agreeable to her, that somehow that this mother then coaches the child to make a false allegation of sexual abuse, and there you go, she gets what she wants. He can't see the kids anymore, and she has tremendous leverage. Unfortunately, the system responds to these allegations with great skepticism. And what I mean by that is, when there's an allegation in a divorce case that a father sexually abused a child, they go, oh, this is a custody battle case. We do it. Law enforcement does it. Child protection does it. It's a different class of case. And it's unfortunate. You still need to walk through the door and begin this investigation objectively. Because even kids who have parents that are polarized and angry with one another, even kids that grow up in households where there's divorce and there's animus or anger between the mother and the father, where there's a terrible breakup, even in cases where the parents are polarized and vindictive, kids can get abused and may have been sexually abused. It has been theorized that you may have credible allegations and real allegations in the context of a matrimonial case, simply because if a child who's living in a household is being molested by the father or stepfather, they may remain silent because they're afraid of the father, or they're afraid of breaking up the family, or they're afraid no one will believe them. All the things that you will study later or may have studied already that are related to the child sexual abuse accommodation syndrome and other research on the dynamics of incest and intrafamilial abuse. What you may know already, and I'm going to tell you if you don't know, is kids don't tell right away, especially in families. They don't tell right away. Even the greatest critics of what we do, even the smart people and even the not so smart people who believe that child advocates are overzealous, that child advocates are looking anywhere and everywhere to find abuse and neglect, and that we overstate things, and we run amok, and we are involved in witch hunts. Even our biggest critics, some of whom are highly credentialed academics and very wise people, whose names I won't mention in this class, but other classes, agree that kids don't tell right away. You cannot find any credible researcher, academic, or anybody who knows anything about child abuse, even on the other side, I'm trying to say, even on the side who jumps at the chance to highlight our mistakes, to say that kids tell right away when they're molested within the family or within a household or by someone they know, trust, or love. That is the way it is. It's unassailable. So we know that. So if kids don't tell right away, now people may quibble about the reasons, but they're pretty universal as well. They think they might get in trouble. The guy might have threatened them. The guy may not have threatened them directly, but they're indirect threats. They may think they're going to go into a foster home. They may feel that they're going to make the marriage break up, or that their mother's not going to believe them, or their siblings aren't going to believe them, or people are going to look at that differently, or that somehow they brought it upon themselves, that they were complicit, that they were involved, they invited it, or it never really happened. There's a billion reasons why kids don't tell. So let's go back and think about child custody cases or family court cases. So if we know that kids don't tell right away, and kids keep it in, and they maintain this secret for a lot of reasons that have to do with preservation of the family and preservation of themselves, it kind of makes sense that once that threat is gone, that they might tell. By that I mean, once dad or stepdad's living in Tom's River, and they're living here with mom, maybe they feel there's what we call safe harbor. Maybe they feel that they can express themselves now. Maybe they feel they can tell. That doesn't make these cases any easier. That doesn't make these cases any more credible. But it certainly makes it clear that sometimes there can be true allegations. So we can't simply reject these cases. And the data tells us, and it's in Professor Meyer's book, it's a little old, but I don't think it's changed. The data tells us that among cases, among cases involving child abuse, let me look at what Meyer says specifically so I don't misstate it. Well, here's a set of research. The setting of the divorce and custody dispute does seem to raise the likelihood that clinicians will find an increased number of fictitious allegations. However, in this study, nearly 70% were deemed reliable, arguing strongly against the practice of dismissing allegations in custody disputes as most likely false. Okay? Now, if you look at the universe of cases, some of them are going to be false. And I don't like to really use the word false. Erroneous. They're not true. Okay, whether they were designed through deception or not is a different issue. And I don't think there's very many of those. But there are cases, among all cases, that are erroneous. They didn't happen. And the allegation is not true. There's more of those within child custody dispute cases. But that doesn't mean they're all or even most of them. This research here says 70% of them were deemed reliable. 30% is not a good number, but if you think about it for a minute, if I'm not making these numbers up, but if 1 out of 50 typical child abuse cases is erroneous or false, and 3 out of 10, I should have used the numbers that jive, but if 1 out of 50 would be, 5%, 0.05%. If 1 out of 50 is false in the regular child abuse cases and 3 out of 10 are false in child custody battle cases, the disparity is significant. But we also need to think about the fact that that means 7 out of 10 are reliable. And simply don't ignore these cases. And you know what sometimes happens? One of the more I think, persuasive explanations for why you get a lot more here isn't because you have really sinister moms out there who are going to use their children as pawns to get some sort of civil advantage in the court system, although there may be a mentally disturbed person out there like that. What I think may happen in some of these cases, more than some of these cases, is, you're starting out with two people that can't stand one another, right? And among, and looking at those two people that can't stand one another, they come in all shapes and sizes, and you have some others who really know that guy. And they may know that he's creepy at times, and he's got weird sexual desires, because I was his partner. I know how he thinks. I know the things he's capable of doing. So you have a mother like that who knows what turns him on, and if it runs towards the deviant, albeit legal, it runs towards what might be considered deviant, they may be highly suspicious of them and highly suspicious of leaving their kids with that guy. Plus, he may have hit them, he may have done all kind of bad things. So when you have people that are at odds with one another, and you have a mother who's typically the primary caregiver and is highly suspicious of him, and thinks remember, she was married to him at one time, but now he's a scum. The worst sort of scum. And that's obviously a biased person, right? So imagine the child, now you're going through a divorce. The child now has families in two different places, right? The father's here, the mother's there. It probably wasn't pretty just before the papers were signed. It probably wasn't pretty just before the separation occurred. Well, that separation in and of itself can cause a little one, right, to act in ways that are different from the way they acted before. They may neglect their bed. They may have nightmares. They may not want to go there anymore. I don't want to go there anymore. Maybe they don't like the way it smells in Tom's River, or they don't like the fact that the Ciba-Geigy plant used to be there, or maybe they just don't want to be there because they miss mom. There may be a million reasons why that child doesn't want to be there. Okay? It could be abuse. But what happens, I think, is some of these mothers begin to put A and B and C together. And if you look just at the generic indicators for sexual abuse, they may be bedwetting. They may be the child doesn't want to go there anymore. They may be the child has night terrors. They may be the child acts this way or that way. Many of the symptoms are ambiguous. Many of the behaviors that kids exhibit that we can look at, pay attention to, are highly ambiguous and capable of a million interpretations. One of them might be sexual abuse. So if you have a mother who's polarized and angry and suspicious and thinks that her ex-man is deviant, it's not out of the realm of reasonable for her to start questioning her daughter. Maybe very aggressively. Right? What's going on over here? He's got a new girlfriend. Where did she sleep? Where do you sleep? What happens? What are they wearing? What do you wear? Does he ever touch you? Does she ever touch you? And sometimes, especially with the smaller children, I believe that that caregiver can misinterpret the child's behaviors and also misinterpret what the child says in response to their questions, and then become convinced that something happened, and may even validate that and reinforce it in the child's mind and make an allegation. And then the child knows that mom made the allegation, or maybe they get a little bit older and they realize mom made the allegation and they don't want to go against mom, and they may run with it or they may reinforce it. There's a lot of different things that can happen in this context, but I really believe that a lot of these mothers and caregivers misinterpret their children's behaviors. They are so unobjective that they are prime for misinterpreting their child's behavior and prime for asking the wrong kinds of questions and misinterpreting their child's responses to those questions and then running with it. Now, you may have a mother who truly discovers abuse or neglect, or a child makes a pretty good disclosure to, but the mother's a little flaky, or she's a little odd, or a little different. And let me tell you something. Once the court system, or the authorities, or the child protection system declares you a little flaky, pretty hard to get unflaky in their eyes. If you're perceived as someone who's overreacting, if you're perceived as somebody who's overstating this, if you're perceived as someone who is unreliable once, it's pretty hard to get your reliability back and your believability back. And sometimes what happens is you really believe your daughter was molested, and you go to the courthouse and you don't get the reception you thought you'd get. So you start getting panicky. And while you may have been welcomed, it may not have been perceived as odd or different or troubled in the beginning. You start working the phone. You start making calls. And you start trying to influence this one and that one. Because you really believe your kid. I mean, some people who are truly interested in their child's welfare, I think, get swept away in trying to get the system to believe them and believe them now. So much so they become their own worst enemy. And that the vigor, the passion in which they try to advance their belief that their child was molested, in short order gets turned into they are unreliable and kooky. And once that happens, they're doomed moving forward. Because it's very hard for the system to take you seriously again. It's not your fault. It's a sad thing that happens, I think, in some cases. In the 1990 sitcom Seinfeld, one of the characters was a a woman named Elaine Venice. And Elaine went to the doctor now and then, and she learned by peeking in her chart once, when the doctor left the room, she looked at the doctor's notes and it said, difficult patient. So she spent the better part of that episode trying to undo that and trying to go to the doctor and the other doctor she went, and that chart went with her. She had to go see a neurologist or a cardiologist. You know, the GP's chart followed her around. So this tag of difficult patient followed her around. And she tried her best. She really did try her best to undo that and to not be a difficult patient. But it was hard, primarily because she wasn't been a difficult patient. But even if she wasn't, the effort she put in trying to undo the difficult patient tag caused her to be even kookier and considered even more problematic and more difficult. So it's kind of a similar dynamic, I think. It happens to some of these women. So child custody battles, the upshot of it is not all of them are false. Many of them can be true, actually. Just because an allegation happens in the context of a matrimonial case or a custody battle doesn't mean it's false. And a system should not reject it out of hand. Okay? Even kids in those houses with those kinds of parents have been the victim of incest in the past. Any questions about that? Now, we also talked about, for the better part of all of our classes, about language and words and statutes and how the way statutes are interpreted or how the legislature uses words affects outcomes, right? And we talked about Galloway and things like that. I was looking at a number of bills that are pending in Trenton now, and I reproduced some of them here. And since we've been talking about language and we've been talking about our lawmakers and how laws are made, I think it's kind of interesting and instructive to take a look at what's on the agenda in Trenton right now when it comes to child maltreatment. And some of them address issues that we've been talking about. Now, a lot of people were very upset about Galloway in the 90s or whenever his case was, because he shook a baby to death and he wasn't considered a caregiver or someone who had assumed a legal duty for the care and custody of the baby in that case under the endangering statute. Now, I don't know if it's this one. Yeah, I think it is. There is a bill. When bills are offered for amendment, I'll try to make this bigger, they underline the section that they want to add or change. Now, this is in Chapter 14 again. It's the sexual assault law, not the endangering, but you'll see that this is on the legislature's mind for some reason. Look at subsection C. This is that one, if you commit a penetration and the actor has supervisory or disciplinary power over the victim, this is B now, of any nature or any capacity. They want to clarify that. I think it had to do with because there was a volunteer who was accused of something. I'm not sure how that matters, whether you're a volunteer or not. Because either you have a special relationship with a child, even if you volunteer to do it, or you don't, whether you're paid or not. But there must have been a case where something like that happened and the outcome wasn't as people expected. Look at subsection C. The actor is a resource family parent, a guardian, stands in loco parentis within the household, and here's the new language they want to add, or is in a dating relationship with the victim's parent. Resource family parent or guardian. So you could be dating the parent, you could date the resource family parent, or date the guardian, and you are on the hook for the more serious allegations under Chapter 14. Now, a lot of these things go in and out of Trenton. They never pass. And I haven't studied this enough to know whether I agree with it or not. But, you know, it really, to me, my first inclination is bad law, don't pass it. Okay? Because, you know, it creates problems for defense lawyers and primarily for prosecutors here. What if you're dating the mother and you never go to the house? I mean, I've dated people where I never was in her house. I never met her kids. If I date somebody, well, get me out of this. If a man dates somebody, right? If a man or a woman, it could be a woman, right? If a man dates a woman and has 20 dates, never goes in her household, and God forbid, you know, he molests the kid, What does that have to do with anything? You know, it's not the dating that gives him special access and opportunity over the child. It's his presence in the mother's life. It's what he's doing. It's what his relationship is to the child. These crimes are based upon the fact that the child is in a subordinate relationship to the guy and somehow feels compelled to do what he says. And the traditional law says if you're a parent or a guardian or you stand in loco parentis. Now that's a Latin word that simply means if you're in the house and you act like a parent. You do the things that a parent does. That's it. Who cares if they're dating or not? Right? If you're in a parent's life, in another parent's life, so much so that you act like a parent, the kid sees you as a parent, then that ought to be the more serious offense. Now we're adding in, just very broadly, a dating relationship with the victim's parent. And you may say, well, the heck with him. If he dates a woman and then he sleeps with her daughter, that's a bum and ought to be prosecuted severely. Perhaps. Perhaps. But what's happening here, you know what you want in the law is you want a sense of equilibrium. You want the things to be substantially similar. So if a guy dates a woman 4 or 5 times but never meets the daughter, is he as culpable as somebody who lives in the household and tells her what time curfew is? And drives her to school? That lives with the mother? Are they the same thing? No. I mean, this guy who's simply dating the mom but doesn't have that kind of significant relationship with her yet is as guilty as the guy who's living with mom and telling the kid what time curfew is and driving her to the school dance and making her doctor's appointments. That's parenting. Okay? That's in loco parentis. And you don't have to date. It's not about dating. It's about your position in the household. So, you know, there probably was some cookie case somewhere in the state, and they want to pass a law. But Galloway would have been on a hook with this one, though. Everybody would have liked this. They'd have got Galloway with this one, because he was certainly dating the mother. Let's see what else is in the hopper in Trenton. Okay, we're going to talk about mandatory reporting. There's a law pending that requires that sexual abuse upon a child be reported to law enforcement. When we learn about mandatory reporting, it might even be this class, I forget, but anybody who has a reasonable suspicion of child abuse, including sexual, physical, and anything else, psychological, failure to thrive, emotional, you have to report it to Child Protective Services, DIFAS. This requires you report it to the cops. Whether that's wise or not, I'm not so sure either. I'm not going to get into this one right now. But that's out there. Well, here's another one as a photographer, as an amateur photographer. Again, I know the case it came out of. This guy did this in our county too, and I was involved in the case. But again, bad cases make bad laws sometimes. Okay? This law says it's a third degree. I didn't even see that. It's a third degree if you photograph. Let's get rid of the rest. You can do a photograph, videotape, record. Let's just stick with photograph. Does it roll? This job did. You're a third degree criminal if you photograph a child without the parent or guardian's consent. In circumstances in which a reasonable parent or guardian would not expect the child to be subject of such reproduction. That's the only thing there that kind of is limited. But even that is vague and wishy-washy. And it puts it, in the mind of the parent or guardian. So you can't take pictures of kids anymore unless you get the parent's permission. I've taken pictures of kids with my camera. One of the things Giselle Enriquez in our office said, why don't you take pictures to put at the Child Advocacy Center? You're an amateur photographer, you mess around with the digital camera. Take pictures and we'll put them on in the center. We've never really decorated the walls of the center yet. So when I would go to the park or whatever, I have pictures of animals, people, what are you going to shoot? That's what people shoot, right? People, animals, and buildings. What you do when you're a photographer? Well, they just ruled an entire class of humanity. Not only can't you go to jail for 5 years if you get caught. I mean, it's bad. don't think it'll pass. I don't know enough about it. Who knows? Who knows? But you know what happened here? You know what this case? I couldn't figure it out until I scrolled down. Every statute that's pending has at the bottom of it a statement of purpose. This one not only tells you what the statement of purpose is, kind of gives you a little bit more, they're calling it video voyeurism. Well, what is that? If people are in public places, is that voyeurism? Well, even the guy, this is Ringwood, it's in Passaic County. This is the case. The sponsor was prompted to introduce this bill when some guy, and he did it in Bergen County, he did it in Passaic County. Now, I didn't know he was at the swimming competition. I thought it was some other competition. But he was at high school events that he had nothing. First of all, he's some 60-year-old guy or whatever, and it doesn't help that he's creepy looking. And he's a creep. There's no doubt why he's doing this. We know what he's doing. But anyway, he's in a public space at a high school game. And he's got the seat right where the cheerleaders are. He's taking picture after picture. He's creepy looking. He's clearly sexualized what he's doing. I mean, we know what he's doing. But bad cases make bad law, right? Now, apparently he must have also did a swimming competition. So he's going up and down Bergen and Passaic County at high school events where he has no kids, and he's objectifying and fetishizing the girls who are on display, cheering and swimming and all that. And so the parents, and look, I'm not defending this creep one bit, don't get me wrong, but I'm saying is bad cases make bad laws. So the parents can shoot the same girls doing a triple backflip, but if he does it, it's 5 years in prison. So how do you do that? How does that make sense? So is this 1984 where our purpose, where our private thoughts about what we're documenting are criminal? It's not the photo that's criminal, it's what our desires are when we go home with the photo. Simple as that. And that may be a good thing to ban. This is not good language to do that, though. And once you get into doing that thing, you'll never find good language. It'll always be overbroad. That's in part why it is tricky to punish people for their thoughts and private desires. Go ahead.
So if this law came into effect and I were taking video of my daughter in a swimming competition and I got the kid next to her and the kid next to her, I could be charged because I was photographing a child without their parents' permission?
Well, conceivably, yes, but let's take a look at that escape hatch at the end here. Remember, it says, and under circumstances in which a reasonable parent or guardian would not expect his child to be the subject of such reproduction. Actually, the area, the kind of photography that prompted this bill and involves the issue that they're so concerned about is exactly the kind of area where you would expect people to take pictures. At a swim meet, at a football game, at a cheerleading competition. We just don't want him taking pictures, right? But look at it. It says, is this a place where people... Look, if you're in a dressing room or you're on the beach behind a gazebo, taking a little one and changing her bathing suit, or I don't know, give me an example of a place where a parent has an expectation of privacy with their kid. A bathroom, your own house, your backyard. If this guy climbed a ladder and he's taking pictures of your daughter in your backyard, I think you got a reasonable expectation that nobody's going to take pictures of you in your backyard, especially if there's a fence. And even that's arguable. I don't know whether that's right or wrong, but if you're at a Bergen Catholic football game, don't you expect somebody might have a camera? Not only that, there's a billion cameras there now. Everybody's got a camera. This is also in response to the ubiquity of cameras now. I mean, anybody can take a picture at any time. You can't even ban photography at Madison Square Garden anymore, or I go to Seton Hall games all the time at the Rock. They gave up. I bring in all kind of camera stuff. Right? They just check it, make sure I'm not bringing in something they don't want. But 5 years ago, you weren't allowed to go, oh, no cameras. You're going to and they worried back then that we might reproduce the NFL's property, or the NBA's property, or the NCAA's property, at a time when cameras were as junky as they came. Now you can actually you can take really good video. Now they let them all in because there's no stopping it. You really can't stop it. But anyway, so you had a comment? Somebody back there.
No, you answered it. Because I was going to say, what about like a reporter that, like in the Guardian or the Daily Record, they take pictures of athletes and stuff, but that isn't.
Yeah, yeah. But again, remember, it's not about these. First of all, it starts out broad. You cannot photograph kids without parental permission. That's the rule. The one exception depends not upon whether you're a reporter, not upon whether the person was doing it for prurient or sexual or fetishist reasons. Okay? It's not about that. It's about whether a parent thinks it's a good idea or not. Whether the photography is okay. You start out, it's never okay, unless a reasonable parent would think it's okay based upon the circumstances. And I think the case that it was inspired by, it wouldn't work. That guy would not be prosecutable under this law, because everybody's shooting pictures there. We just don't like what this guy's thinking about when he shoots photos and what he's shooting photos of. You might say here, if the purpose for which the photo is created is to sexually gratify the actor or any other person who might view the photo. And I lifted that primarily from that endangering statute, because that endangering statute says it's a crime to photograph kids in a prohibited sexual act. That sounds reasonable. Kids ain't supposed to have sex. But among the prohibited sexual acts is nudity. And we get plenty of cases over the years where kids are filmed in their backyard with no pants on or in a bathtub throwing a duck or something. You know, most of the time they don't report those. Every now and then you come across one, and they were cleaning out my husband's things and I found this. You know, the kid's in the kitchen with no pants on, you know. I don't know why he has it. It's suspicious, but where am I going with this, you know? Because the statute, I think it was appropriately and elegantly drafted. It says, if the nudity, right, was documented, if you photographed the child naked or partially naked for your sexual gratification, or the actor is the guy who took the picture, for the sexual gratification of the actor or anybody who might look at the picture. Now, that puts the onus, which would be a nice way to handle this one, back on the guy's purpose, right? Why do the people creeped out when the guy with the black socks and the short shorts is sitting over there by the cheerleaders with the camera? Because they feel, and probably they're 100% right, he's photographing them to go masturbate or to go do whatever. He's turned on by it and he's creepy and he's looking at little girls. Okay? That's why they're doing it. Not that the parents feel particularly invaded or something, that this is a forum where you shouldn't have cameras and my kids ought not be photographed here. Everybody's photographing your kids here. So the statute can be retooled. I don't like it one bit. But if you're going to fix it, put the onus on the photographer. And you say, well, how do you prove that? Well, we've proved it many times. You prove it when these pictures are in a folder called Young Lolitas. And there's girls naked or girls that age having sex with other girls or adults or other things. And these pictures are with them. And some guys you won't discover that, and some guys you will. You'll find evidence, especially picture takers. By definition, picture takers are catalogers. They like saving stuff. So if they're creepy and they're perverse and they're criminals, they ain't only saving this stuff, they save everything. And history has taught us that, and experience has taught us that. So this guy with the shorts and the camera, look at him. Well, you don't need to Kurt me and every other legitimate photographer, right? That's an example of a statute that's what we call overbroad. It's too wide, it's too big, cast too wide a net. It catches all of us innocent people just to get the guy with the camera and the track meet or the swimming meet. Okay? Any other commentary on that? Let's see what else is brewing in Trenton that's relevant to children and justice. Look, I don't know if you can see that up here. I'll read it to you. I don't even have to go down any further. This prohibits smoking in automobiles when children are present. As a reformed, unaddicted smoker, I don't want anybody smoking around my son. I don't want my son to see me smoke ever. I stopped smoking for 7 years. I started for a little time, stopped. It's terrible. My mother, I didn't want to go there. But, come on, man. We need to pass a statute. I wonder what degree crime it is. Smoking means inhaling the smoke from, or the possession of a lighted cigar, cigarette, pipe, or any other matter or substance which contains tobacco or any other matter that can be smoked. Okay, it's a $100 fine, so I shouldn't be too... Well, where is it? Is it in 2C? Oh, Title 39. Yeah, this is a motor vehicle law. It's not a crime. I stand corrected. Sponsors, with all deference to Assemblyman Charles Maynor and Matthew Millam from Cape May and Cumberland and Hudson. Wow, they have north-south support here. So you can get a $100 fine maybe if you're smoking a car and there's a child there.
But unless you get pulled over for something else.
Oh, it's a secondary offense? I didn't even scroll down, but...
So unless you get pulled over for something else, you would never know if they were smoking in the car.
Oh, well, what about if you're pulled up at a light and you see them smoking and the kid's there? I mean, they can see you through the window. We have glass windows, so they can spot you. But I thought you were saying, and it may be the case, excuse me, when they first passed the seatbelt law,
Yeah, they had to pull you over.
yeah, they had to pull you over for one thing and then get you for the seatbelt. They changed that now. It's a regular primary offense now, but... Okay, I'm going to take a look at the reading that you had in this learning module. In Professor Myers' Chapter 2. Now, this is it. There's no more Professor Myers. You got to get the book if you don't have it already. But what he does is he talks about the adversarial system of justice, and then he gives you a case example. Okay? Now, in the United States, we have a very special kind of system of justice where people are presumed innocent unless and until they are proved guilty beyond a reasonable doubt, okay? And the way that we get to that conclusion is primarily twofold. You have lawyers who represent the interests of the government and lawyers who represent the interest of the accused. And then you have a jury who makes a decision about responsibility, whether it happened or not. And that's called the adversarial system of justice. The prosecutor gets together all of her evidence in the best way she can marshal it together and attempts to prove that the accused smoked a cigarette in the car or that the accused was taking photos at a swim meet when most parents would not think that was a good idea. The prosecutor is someone who has to get all of their evidence and argue the best they can for guilt. On the other hand, the defense lawyer has to argue the best they can to reflect the interest of their client and demonstrate that they're not guilty. So you have this clash of two parties, this clash of two attorneys, sometimes more than two attorneys, sometimes two sets of attorneys, where the hope is and the expectation is that by both sides arguing vigorously for their view, that you will arrive at the truth. And that truth will arise from the jurors listening to it neutrally, objectively, and dispassionately. People who have no interest in the case, and we'll talk more about that later. That's the adversarial system of justice. Now, we looked at some statutes a moment ago. I want you to understand a little bit about how laws govern behavior and children in our justice system. We pretty much understand how statutes arise now, right? We looked at some of them. Our legislators in Trenton or our legislators in Washington, they pass laws that are designed to protect our health, our safety, and our welfare, to keep us safe and to advance certain societal interests, to protect kids, to do a lot of different things, to protect us on the highways. So those things are called statutes, S-T-A-T-U-T-E-S, not statues like the ones in front of this building, statutes. Statutes. Those are the laws. Okay? So that is a source of law in New Jersey, a statute. There are criminal statutes and civil statutes. The smoking the cigarettes in the car, is that a criminal statute? No, that's a civil statute because it's a motor vehicle law, and motor vehicle is civil. Okay? Taking pictures of children without parents' permission, if that passes, that would be a criminal law because it could result in probation or incarceration, jail or supervision. So you have statutes and laws. You also have something called constitutions. There's a United States Constitution and there's a New Jersey Constitution. And constitutions are usually a little bit more broadly drafted. They are broader than statutes. Statutes identify an evil and they try to remedy it, at least in the criminal law. Smoking is bad for kids. We need to stop that. Let's pass a law that makes it a $100 fine. Maybe people won't do it. They identified an evil. They passed a law specifically about this issue, trying to discourage that kind of behavior. Statutes tend to be specific. Constitutions tend to be broad and sweeping, and they protect certain fundamental rights and privileges that we, as Americans, think are really, really important. You look at a constitution from New Zealand, or a constitution from France, or a constitution from Nepal. They're going to be different. One thing you will do is you'll learn something about what those peoples in New Zealand, France, or Nepal think is really, really important. Because that's what constitutions are designed to do. To set in writing some bedrock principles. Now, in America, our Constitution was drafted in response to our experience as subjects of the King of England. And if you look at the most important part of the Constitution, which is known as the Bill of Rights, where you always hear about the Fifth Amendment, the Fourth Amendment, the First Amendment, and all that, if you look closely at that Bill of Rights, it really is a history book. It's a history book, and it is a description of how we want to live our lives in the U.S. It is a description of how we want to limit the government's authority. So if you look closely at the United States Constitution or at the Bill of Rights, you will see that that is really a contract. That's all it is. It's a contract between the citizens, the people of the United States, and their rulers and their government. That's what the Constitution is. It's a contract. And when we declared our independence, and when our forefathers and the drafters of the Constitution and the Declaration of Independence got together, they said, you know what? We want to make a new government. We want to make a new government that's fair. We want to make a new government that doesn't look like the government we just fought. That doesn't look like the government many of us fled from. We don't want in this new government for people to tell us who to worship and how to worship. And people said, that's a good idea. Because a lot of people came to this country and they fled religious persecution in England and in the Netherlands and in Spain and in Italy and throughout Europe and in other parts of the world. They came here because they were persecuted where they came from. And when it came time to create a new country, they said, you know what? Let's make sure that the new government doesn't do the kinds of things that we find offensive. The kinds of things we really care about. So we want to be in a government, we want to be under the rule of a government that allows us to practice whatever religion that we want. Write that down. Put it at the first, it's so important, make it the first rule between us and the government in this contract. Write that down. wrote it down. The other thing is that we really think is important is that we ought to be able to criticize our government. Because around Europe and in England and in France and in Italy and probably throughout the world, if you said anything bad about your government, put you in handcuffs. They charge you with an offense. We don't want to live like that. We just fought England for our freedom. We want to have a new government and a new way of life. And we want a way of life where we can assemble, we can gather together and say the government's bad if we want to, or we can proclaim the government good. We want to have this freedom to say what we want, not get in trouble. Write that down. Put it in that same first one. It's as important as religion. Freedom of the press, freedom of assembly, freedom of speech, and freedom of religion. Write that down. Wrote it down. And interestingly, I said the Second Amendment. Right? The Second Amendment is, I said that the Constitution is really a history book. And if you go look at the Second Amendment, and it's also about our negative experience with our king, King George of England, with the monarchy, the way that people lived in Europe at the time. If you go look at the Second Amendment, it says, you have the right to bear arms. Now, all the folks who believe in ability to have weapons in your home or carry weapons believe that that Second Amendment has some special meaning and allows us to keep weapons on our person anytime we want. Who knows? I don't really care one way or the other about that issue, personally. Bottom line is, this was drafted in the 18th century, and it was drafted because we didn't like when we lived in England, or when we lived in the Netherlands, or when we lived in Italy or Spain, or wherever we lived. We didn't like the fact that the government told us we can't have weapons and bossed us around with their weapons. We ought to be able to have weapons to defend ourselves. We ought to be able to have militia. Now, militias aren't that important anymore, but in the 18th century they were important. It also says something very peculiar. It's not peculiar to them. It was not peculiar then. It's peculiar to us now. I don't think any of you would tolerate what is authorized by the Constitution. Or actually, it's not authorized, it's deauthorized. I don't think any of us would tolerate this, even if it wasn't in the Constitution. But the Constitution says that the army can't come through your town and drop off a few troops in your house, and you got to put them in your bedroom. There shall be no quartering of troops. Now, in England and in France and in Spain and in Italy and Denmark and all over Europe, if the army was coming through town and they needed a place to sleep, you're getting out of your bed and soldiers would be sleeping in your house. Troops would be quartered in your home. You had to feed them. You had to take care of them, whether you believed in the war or not. So if you look at that Constitution, and if there's any doubt in your mind that this is a vestige of an earlier time, any doubt in your mind that this is not a historical document, it is, right? It talks about that. And now, you know, no one could come through Aberdeen, New Jersey, or Perth Amboy, or Patterson, or Teaneck, and put a bunch of soldiers in your house to sleep there while you slept on the floor because they're coming through town. There shall be no quartering of troops. The Fourth Amendment protects us against unreasonable searches and seizures. Let me tell you something. In 18th century England and in 18th century France and throughout Europe, if they were the slightest bit suspicious of you, they rounded you up. They looked through your things. They searched you whenever they wanted. In the name of law and order. Not in this country. We don't want to live in a country where people can just search our purses or our cars or our pockets or our homes without having a damn good reason. Write that down. Make it number 4. The Fourth Amendment. No one is allowed to search people's stuff unless they have probable cause. Number 4. Similarly, throughout Europe in the 18th century and 17th century, you could be hauled off in England to the Star Chamber, in France to the Bastille, to any one of these prisons without even knowing what you were charged with. You certainly didn't have a right to a lawyer. And they'd bring you into the interrogation room, and if you didn't talk, they would beat you till you talked. And if they beat you and you didn't talk, they'd bring you into court and say, he didn't defend himself, he must be guilty. Because you didn't have a right to remain silent. You didn't have a right to a lawyer. You didn't have a right to know what the hell you were charged with. That's the way they rolled in Europe in the 18th century. Write that down. We don't like that. Put that in 5 and 6. Number 5, right to remain silent. Number 6, the right to an attorney. Write that down. Okay. You have the 7th, 8th, 9th, 10th Amendment. The ones I just went over are really the ones that involve criminal law. And there are others in the Bill of Rights. Some of them, the First Amendment, the Second Amendment, really don't involve criminal law. They put together this Bill of Rights and they said, all right, remember it's a contract, before we consent to you ruling us, now this is largely metaphorical, I think you get that, but before we consent to you ruling us, you got to sign this contract. And that's the Constitution. It's a contract between us and the government. And it is, in every part of it, a limitation on government authority. Okay? It limits how they can search us. It limits how they can interrogate or interview us when we're accused of a crime. It limits how they can tell us when we can say what we want or not say what we want. It limits their ability to tell us who to worship. It limits their ability to tell us how to report what's going on in the newspapers or on the radio or on the television. It's a limitation on governmental authority. It only applies to governments. If Federal Express searched your package at Newark Airport, that's not unconstitutional. It's got nothing to do with the Constitution. The citizens didn't make a deal with Federal Express. They made a deal with with the government of the United States. So the Constitution only applies to governments. Okay? People, now that doesn't mean Federal Express can search our things. There are other laws and procedures that might be involved with Federal Express looking at our stuff. But it's got nothing to do with the Constitution. You know? If that park where the Wall Street, what was the name of that thing? It's died out. The Occupy Wall Street. That was a private park. I think it was called Zuccotti Park. If Grandpa Zuccotti wanted to throw everybody out, he could. It's his park. Wow, we have the right to assemble. Not on my property, Go ahead over there. Go into Central Park. That's okay. The government runs Central Park. I own Zuccotti Park. Well, whether old man Zuccotti could throw them out or not, even if he did, it wouldn't be unconstitutional. It's got nothing to do with the Constitution. He's a private property owner. Right? The Constitution is a contract between the people and the government. So that's another way that we have laws in this country. Statutes, we looked at some of them. Constitutions. Now, when we pass laws, they cannot conflict with the Constitution. Supposing that law said, and groups of photographers are not allowed to gather and talk about photographing children. Wait a minute. Maybe there's something they want to stop, or some evil they're trying to remedy, or some issue that happened in some town in New Jersey. But you can't tell groups of photographers not to get together to talk about stuff. That law probably would conflict with the First Amendment, the freedom to assemble, right? Freedom of speech, maybe. The reason why we have these super PACs, as much as they rattle liberals and some Republicans and some Democrats and some conservatives, is because the Supreme Court felt that there was the freedom of speech that people had, and political speech is a form of speech. So as long as you're a real rich guy who is not coordinating the collecting and spending of money for a political candidate with that candidate, you can have these giant corporations that put TV ads on to favor one candidate over the other. Mostly negative ads. They have these super PACs. It's getting a lot of press lately because of the primaries. PAC means Political Action Committee. And a super PAC is one usually where millionaires start an organization that's designed to buy ads that favor Mitt Romney or Newt Gingrich or Rick Santorum or whoever, or Barack Obama. And they're beholden to nobody because they are a private entity. And the Supreme Court ruled very recently. Barack Obama wasn't happy. He made a comment to her State of the Union address 2 years earlier, which prompted the Chief Justice to go, not true, in this very formal environment. But the Supreme Court said, look, that's speech. We may not like it, but it is what it is. When I first started prosecuting cases, they said it's okay to burn the American flag. It's a form of speech. The judge I appeared before hated that ruling. This old-time Italian from Patterson hated it, but he had to follow it. Burning the flag is okay in our country because it's speech. And with these rights and with these limits on governmental power, sometimes there are unpopular things that happen that we need to tolerate. Some people may think burning the flag is not a big deal, and it's okay, and they want to say something by doing that. Well, you're protected in this country. You can do that. You can do that. The Nazis were able to march in Skokie, Illinois in the 1980s. I think 80s, 70s, whatever. But the Nazi Party, or whatever they call themselves Nazis, they dress like Nazis, they were able and protected by the United States government to march peacefully in a suburb of Chicago. No one agreed with it. The government didn't agree with it. But it's okay because they got the right to assemble as long as it's peaceful. So even though people have unpopular ideas or want to create super PACs, that same Constitution protects them, even unpopular ideas. It's part of the American experience. So you have these constitutions, you have these statutes, and then you have things called regulations. Regulations. Now, when you set up the Division of Youth and Family Services, for example, even the Motor Vehicle Department, you might pass 10 or 20 or even 30 or 40 different laws, statutes, about driving cars or protecting kids in the state. But there's so much to do to get that message out, to regulate the day-to-day behavior of people, that you can't put it all in statutes. So sometimes there's regulations. I'll try to give you an example. I'm going to make something up, but let's try to keep it within the children and justice world. Let's say it's under Title IX and it's a law, it's a statute. The Division of Youth and Family Services shall ensure that all foster parents are appropriately screened and can provide a healthy and safe environment for a child before they are permitted to apply for foster parents, to be foster parents. Okay, there's a nice law, right? Well, there's a lot of language there. They have to be screened, they have to be appropriate, they have to be able to have a nice environment for the kid, right? All that's in that law. Well, there's more to it than that. How do you determine what a nice environment is? How do you screen them properly? Where do they apply? Do they have to fill out a piece of paper to be a foster parent? Do they have to pass a background check? You can't put all that in the law. So they passed a law that says all foster parents, have to be appropriate and have to maintain a household that's safe and healthy for the child, or whatever I said. They'll pass a law. And then the agency will pass a lot of regulations. They can't conflict with the law. They can't say, well, foster parents don't have to have a clean house. Pass a regulation. A foster parent's house could be semi-clean. No. If the law says it's got to be clean, then it's got to be clean, whatever that means. I'm being silly. But you can't pass a regulation that's inconsistent with the statute. But you can have a book of 1,000 regulations that gives meaning to that one phrase in the law. So there's the law, and then there's the regulations that make it work. Does someone not get regulations? Okay, so you got statutes, constitutions, and you got regulations. These are the kind of laws that govern the behavior of people, and things that are like laws, like constitutions and regulations. You've read some case law here. You read the case of State in the Interest of MTS. You read the case of State versus Galloway. Whenever there is an issue about what the law means, or a question of interpretation, and the litigants want to resolve that issue, they can apply to the court for clarification. And that's what appeals are about. So courts interpret the law. The legislators pass the law, right? The agencies pass the regulations. The government creates a constitution. And then when there's concerns about whether something's constitutional or about what a law means, courts are asked to interpret what those laws mean sometimes. What does force or coercion mean? What does assume a legal duty for the care of a child mean? Anthony Galloway wanted to know. Anthony Galloway felt he was being too severely punished under Chapter 24, endangering. So he argued that that part of the statute was mistakenly interpreted by the prosecution and by the trial judge. So they appealed, and you have the decision of State versus Galloway, interpreting what that phrase means. New Jersey has a criminal code. I told you that. Everything that you can't do in New Jersey that could be a crime is written in the criminal code. Before there was a criminal code, though, there was something called the common law. The common law. The common law was based upon the customs and traditions of the people. The common law was not written down. The way that you could find it is just because everybody knows. Everybody knows that this is the way things are. Examples of the common law that are easy are murder. Everybody knows you can't kill another person without consequences. That's a wrong or a crime. There was common law murder. There was common law rape. A rather well-known example was, it's not relevant anymore, is common law marriage. You may have heard that term. And if you cohabited with a partner for a long enough time, let's say 7 years, you were considered married, as though you had a civil ceremony. Why? Because that was the common law. That's the way things were done. And after 7 years, throughout the ages, right? That's the way things were done. And you know, things just happen that way sometimes. As people socialize and engage in behaviors as groups, certain ways of doing things develop. And as the years go on and new generations of people do that thing that way, it becomes part of the way things are done, or the traditions of the people. That's kind of the common law. I'll give you two silly examples. When I was a kid growing up, we would play street hockey once in a while. You'd play with a ball or a puck, and you didn't know what you're doing. You hit the ball around and try to get it in the goal, and you have 5 or 6 kids on each side. We played street hockey. Now, in a real hockey game, they have a face-off. The referee, or whatever his title is there, he drops the puck, and they have a face-off. They try to take control of the puck and play offense. Well, when you played street hockey, you would put the puck on the ground, and 2 kids would face off. You would lift the stick up and clang the sticks together 3 times. And then you'd go after the puck. I don't know why, it's just the way things were done. And if you ask my father and his father and my son and his son, and for generations in the past, and perhaps generations in the future, that's the way things were done. Kind of like the common law. Now that could change. The hockey sticks could get bigger and stronger, or it could be made out of tungsten steel or whatever. I don't know. Maybe it'll change, but it hasn't. I'll give you another one that's probably more relevant to you guys. If you go to the furthest reaches of Washington State, all the way down to the Florida Keys, or head up Route 1 right to the Canadian border in the most northeast sections of Maine, or maybe head all the way across America right down to San Diego on the border of Tijuana, and you walk in any college or university or any grad school, and the professor is more than 15 minutes late, the class will say it's okay to leave. If there's a discussion about the professor's tardiness and only 10 minutes has elapsed, most students would say, well, you got to wait 15 minutes. Why? You made up that rule. You can look at Montclair State or Purdue or University of Kansas, or go down to South Florida University in Big East Country, or maybe go to San Diego State where the Aztecs play. That ain't written down. People know it. It's the way things are done. It's the way they were done 20 years ago. When I was at Rutgers, that's what we did. I've had classes here say, well, we waited 15 minutes. Maybe. You mean if you're in the office waiting to be seen?
No. If the professor is a PhD.
Oh, really? Oh, so there's a difference. That's outrageous. I'm a Juris Doctor. No, that's a class system. What does that matter? It's a professor. What if they're like Professor Tom Lyon? He's a JD and a PhD. 25? Anyway, so that's your common law. Common laws arise just from traditions. Now, if there was a dispute about whether you wait 15 minutes for a non-doctor or 20 minutes for a doctor, some court might have to decide that. There may be enough students who go, I never heard of that. Every professor wait 15 minutes for. Or I'm a doctor and the students left after 18 minutes. I go, wait, you're supposed to wait 20 minutes. I sued. So now the court has to interpret the common law. That's how you got judicial decisions. Before there was a code. Now we have a code. But back in the day of the common law, when there was only the common law, the only written law was the court decisions. That goes back hundreds and hundreds of years. The Salem witch trials has a transcript. And there are reported decisions. And that was in 1670-something, 1680-something. So the practice of courts deciding conflicts of the common law go back centuries. And in a society that relies upon the rule of law, that's the way it worked back in the day. Now in New Jersey and in most states you have, in the criminal law, the Code of Criminal Justice. If it ain't in there, it ain't a crime. If it's not in the book, it's not a crime. In fact, the first page of the criminal code in New Jersey says, the common law of the state of New Jersey is hereby abolished. So they abolished all that. The problem with the common law is it ain't written down, and it's hard to know what's right and wrong. Oh, you can't park there. Why? Because that's the way it's always done. You towed your car. Oh, you're going to jail today. Why? Because you did this. Well, how did I know that? That's too bad. It's the way it's done. The common law, it's better. We value notice in America and in New Jersey. We want to know what's wrong. We want to make sure that it's fair. And the only way to be fair is to know what we're supposed to do or what we're not supposed to do. The common law was problematic because it was based upon tradition and not upon written guides. Now, the court system in New Jersey and in the United States is made up of trial courts and appeal courts, whether you're in New Jersey or in the federal courts. Trial courts listen to the evidence and make decisions about admissibility of evidence. Appellate courts do not hear witnesses. Appellate courts do not conduct trials and hear both sides of the equation or both sides of the litigation live. They simply read a transcript of what happened in a trial court and make decisions about whether the trial judge made errors or whether the lawyers followed the rules. I'll give you more concrete examples. In a criminal trial or a civil trial, let's use a civil trial, for example. Termination of parental rights. Let's say that the Deputy Attorney General of New Jersey has filed for termination of parental rights. And the accusation is that this mother is unfit, that she has been unable to redeem herself. There have been reasonable efforts to get her to be a good mother, and she has failed. Despite her best efforts, she's unfit, she's mentally unstable, hopelessly addicted to drugs, and abusive to her children. And her parental rights should be terminated. So the Deputy Attorney General files a complaint. They have a trial. She produces evidence. The accused mom, she has an attorney. They produce evidence. And let's say the Deputy Attorney General wants to produce evidence that when she was in college, that she was at the college pub and she got in a fist fight with another woman and she sliced her with the jagged edge of a broken bottle to show that she is violent and thus would not be a good parent because violent people present risk to their children. And I want the court to look at that among all the evidence to make a determination about whether this woman's fit or not. Suppose the woman is 38 years old now, and this was when she was in college, she was 22. Well, let's say the judge lets it in, they have the trial, she's found to have been an unfit parent in a meaningful way under the laws, and her parental rights are terminated. She appeals. In the trial in family court, the mother would have testified, perhaps. the prosecutor or the deputy attorney general, rather, would have put evidence on people that saw her hide, people that saw her beat the child. The children may have testified, her former boyfriend or former paramour or former husband may have testified. They put all these witnesses on to tell the story of why she's unfit. They may have photographs of her sleeping in the yard while the kids are running around. All kind of evidence is produced. There's a trial on the facts. The judge makes a conclusion that the fact is this mother was unfit. Now there's an appeal. The mother appeals because she's found to be unfit. An appellate court reads the transcript. They look at the trial judge's rulings. Remember, the trial judge had to make a ruling about whether that evidence that the mother got in a bar fight and sliced another woman's face with the jagged edge of a bottle was relevant. And the judge said, I believe it's relevant, it is admissible, and I'm going to consider that among all the other evidence. Well, that, among many decisions that that trial judge makes, would be on appeal. So one of the things mom's appellate lawyer would say, appellate court, the trial judge got it wrong. He shouldn't have allowed that evidence in. And because he allowed it in, it influenced his decision to take away my kids for the rest of my life and to declare me unfit and terminate my parental rights. So the trial court listens to the evidence. The trial judge makes decisions about what evidence is in and what evidence is out. The appellate courts review the whole case on the papers. They read the record and they look for errors that the trial judge may have made. Appellate courts review errors. Those errors could be whether evidence was admissible or not, whether the statute itself was unconstitutional. Now, you could charge me with photographing a child in Washington Square Park, well, that would be in New York, in Brookdale Park. I'm accused of photographing a child in Brookdale Park. They prosecute me. I argue to the judge that that statute is unconstitutional. Right? So among the things that I argue before there's even a trial, judge, throw the whole case out. That law is unconstitutional. I have a right to take pictures. I've got a right to assemble. I've got a right to document things in public places. It's protected under the First Amendment, freedom of assembly, freedom of speech. I make an argument that it's unconstitutional. That's a preliminary argument. If I win, there ain't going to be no trial. It doesn't matter. The second issue is whether I actually photographed the kid or whether I had the permission. I might say, well, I smiled at the mom. She smiled back. I had her permission. Right? But I don't even want to go there. I want the whole... What is it? Go ahead.
I have a question about, when, let's say in the instance you gave about the parental rights. If the person, if you're going to try to go to appeal, does your attorney, let's say I'm the mom, does my attorney have to figure out the precise part of the trial where they think the judge made a wrong decision? Or do they just send the whole thing to the appeals court and the appeals court checks out?
No, that's a good question. The answer is your attorney has to make arguments of procedural or errors of law or fact that happen below. Your lawyers have to identify what they want. The appellate court isn't going to simply read the whole thing and fish for errors. You have to, the advocates below have to identify what they believe are errors.
Okay, thank you.
Now, one of the issues that you could argue is before there's even a trial that the statute itself is unconstitutional. I make that argument about taking pictures. I lose. Okay? I go to trial. Then I say, you know what, Judge? I want to bring in a couple of witnesses who saw the mother smile at me and I smile back. Well, that's not irrelevant, Del Ruth. That's not relevant, Del Ruth, so I'm not letting that in. Judge, it goes to consent. That doesn't even approach consent. So someone smiled at me. Smiled at you. What does that have to do with anything? Well, I think the jury can interpret that I truly believe that I had the consent of the mom if they hear that. Now, I'm not letting it in. Okay, don't let it in. We go to trial, I lose. I get convicted. There's 20 other issues that I objected, they objected, whatever. Goes to a higher court. Now, the higher court will evaluate it. Number one, I say they got it wrong. The judge made an error below. The trial judge got it wrong. Okay? They allowed this prosecution to go forward. The statute's unconstitutional. The case should have been thrown out. The appellate court can say yes or no. I also say, Judge, they got it wrong here. They should have let in the evidence that I smiled at the mother and she smiled back. The jury could have concluded that that was consent, that she told me indirectly it was okay, and the judge wouldn't let that in. And had the jury heard it, they would have ruled in my favor. that was a meaningful error by the trial judge. You need to change the case and reverse it. So that's what appellate courts do. Now, they have to make decisions, though. Simply because evidence should have been admitted or the trial judge made a mistake doesn't mean that the case gets overturned. So what's the remedy? If the court believes that the judge made a mistake and should have let the smile in, the next question is, was it the kind of mistake that had the capacity to change the verdict? This is important. Was the mistake by the judge the kind of mistake that would be so strong, so influential, that the jury might have ruled differently? You don't have to prove they would have ruled differently, but they probably would have ruled differently. Did it have the capacity to change the verdict? So that's the next question there. So the trial judge hears evidence, right? If there's a conviction, then there's an appeal, and the appellate court listens and sees whether the lawyers for the convicted guy can make an argument that there was an error by the trial judge. They simply look for mistakes. Mistakes of law, not mistakes of fact. They do not substitute their judgment. They may read the whole thing and go, man, I think this guy's innocent. They do not change the ruling or the verdict. Ever. There's one wacky way they can do it, but it's very odd and rare. I'm not going to get into that. The ruling of the jury is final. So what they do is, you know what? The trial judge messed up. He should have allowed evidence in that the lady smiled at Del Russo and he smiled back. And if the jury knew that, they may have found that he had consent. It's that important. And if he had consent, he would have been acquitted. This had the capacity to affect the outcome. So what we're going to do is send it back for a new trial. That's what they do. New trial. And I can still be convicted. They go, well, how do you know she was smiling? What did she do with her face? What does that mean? How did she looking at you? Well, how do you know she wasn't looking at the guy behind you? You know, there may be different issues, but the fact that I believed, and witnesses may have testified that the woman smiled at me and I smiled back, that may be admissible in the new. That will be admissible in the new trial, and we'll get another shot at it. There are lots of different kinds of evidence that the court might ban. Now, if I go to trial and I'm found not guilty, it's the end of the case. Even if 6 seconds later a videotape is discovered with me committing the crime, it's the end of the case. And that's the double jeopardy provision in the United States and the New Jersey Constitution. That's something else that they said, write that down. Because in medieval England, if they didn't convict you the first time, they try it again. If they didn't get you the second time, we'll go to trial again. Well, is that fair? I mean, that deck is stacked. So in America, we have something called double jeopardy. In the criminal law, it can only be tried once. You cannot be tried twice for the same crime. Now, sometimes they try a guy and he's found not guilty, and they may go to the federal courts. You know, sometimes there's a highly charged murder, maybe it has racial overtones, and the guy's acquitted and the community's outraged, and it really looks like he should have been convicted. The evidence was strong, but for whatever reason he was acquitted at the local level. The federal government, they can't try him for the murder, but they'll try him for federal civil rights violations. Different law. So you could do that. You can't be tried for the same crime twice. Excuse me. But you can be tried in the state system and in the federal system after an acquittal if it's for different offenses. Go ahead.
Isn't that what happened with O.J.? They found him not guilty of the criminal, but they got him to discover it? How did they?
Yes. Well, that's a little bit different, and you're correct. He was found not guilty in the criminal trial, and he was found responsible in the civil trial for the same actions. That has nothing to do with double jeopardy, because double jeopardy has everything to do with double jeopardy, but nothing to do with it, because you can't be tried in the criminal courts for the same crime. You can't be tried for the same crime twice. So once he's acquitted, that's it. The murder of Nicole Brown Simpson can never be tried again and go to jail or face jail. The murder of Ron Goldman, never be tried again or face jail. Done. Even if a videotape. He wrote a book that said, if I did it, this is what I did. Why was he able to do that? Because of the double jeopardy clause. Because he thought he might make a few dollars. If I did it, this is what I did. And here's where I hit the knife. If I did it, and if I did it, here's how I slit her throat. And here's how I killed him. But he wasn't vulnerable anymore. It's not the same as finding a videotape of the crime, but it's pretty much, hey. So then the families of Ron Goldman and Nicole Brown sued civilly, and that's different. And the standard of proof is different. Something we can talk about right now. In criminal cases, the standard of proof is beyond a reasonable doubt. That means you have to really, really, really prove your case. Now, lawyers like to use this metaphor, and that is the metaphor of the scales. In the Ron Goldman, Nicole Brown Simpson case with O.J. Simpson, when they went to civil court, the civil lawyer simply had to prove it by a preponderance of the evidence. And that means slightly more evidence that he did it than he didn't do it. If you use the scales of justice, they're slightly tipped in the direction of he did it. If they're slightly tipped or more in the direction of he didn't do it, then there's no responsibility and no money damages. Okay? The remedy in the civil case was money. They sued for the loss of their kids and spouses and dads, and they wanted money. And they got money, but they didn't have money and whatever. But they won. They proved he did it by a little bit more than 50%. 50.05%. In the criminal courts, you must prove it beyond a reasonable doubt. I mean, the scales have to be pretty disparate. They have to be pretty different. You can't even put a number on it. You want to put a number on it? 90%. I don't know. That's misleading. They don't allow us to put numbers on it. They allow us to put numbers on preponderance because that a little bit more is easier to quantify. But beyond a reasonable doubt, we simply say you have to be satisfied beyond any reasonable doubt. Now, we prosecutors, we highlight the fact that the doubt's got to be reasonable. You know, well, I might have said to that jury in the East Village case with the drunken executive from the Gap, say, ladies and gentlemen, you may be asking yourself what happened in that room, and we'll never know what happened in that room. You just simply need to be satisfied that that police officer sitting over there had sexual intercourse with her while she was unconscious or while she was incapable of giving meaningful consent, while she was really, really drunk. Now, you may think, well, maybe she was kind of awake. I don't really know. I wasn't there. Maybe she was starting to come to. There's no evidence of that in this case. You may have some doubt about what happened, but it's not any doubt. It's a reasonable doubt. Do you have a reasonable doubt? Think about what he said he did. Who crawls into bed with an unconscious woman with no panties on and a bra and talking to her about Bon Jovi songs? Is that reasonable? That's the buzzword here, reasonable. That's what he's telling you. What's reasonable? His version or hers? What's reasonable? What was the panic to get from the Upper East Side to that apartment in the East Village when there was a car right in front? Why? Because they were exploiting her. They were taking advantage. Everything in this case points to what she said happened. And nothing points to innocence. Nothing. Now, when you walk out of here, you may say, well, I don't quite know what happened in there. That's not what you're supposed to do. You may even have some doubts about what happened. That's not the issue. You can have doubts. Nothing in life is certain. We might as well pack it up and leave. We might as well not even have a court system. Because no one in this room or anyone who sits in your chair after you leave, for all time, will know exactly what happened. And that's not the question before you. The question is, do you have a reasonable doubt about what happened? You know? And we highlight that. The defense lawyers talk about doubt, doubt, doubt. They don't mention the word reasonable. Doubt, doubt, doubt. You hear the joke that goes around sometimes on the internet? The defense lawyer thought he was very clever, and perhaps he was clever. He's seated in the courtroom, and he is told to the jury, by the judge, that he can make his closing arguments. That's part of what we lawyers do. The prosecutor makes arguments, the defense lawyer makes arguments. It's a murder case. There was no body. They never could find the body, but the evidence was overwhelming that he did it. It was DNA. It was an eyewitness. There was motive. He had an insurance policy. So it was really compelling evidence. He didn't have a lot of wiggle room. This defense lawyer didn't have a lot of arguments to make to the jury. But anyway, he's told it's time to sum up to make his closing comments. And he tells the jury, he walks in front of them, ladies and gentlemen, he has his watch, and he says, ladies and gentlemen, he says, the judge told you about reasonable doubt. That you have to be satisfied beyond the reasonable doubt. Beyond any doubt. And that's not true, but sometimes they say that. I could have checked. Judge, it's not any doubt. But there's lots of strategic reasons why you do things as an advocate or as a prosecutor. So he goes, ladies and gentlemen, the judge told you that the prosecutor has to prove his case beyond the reasonable doubt, beyond any doubt that my client did this. And you know that this body was never found, but I am going to tell you right now that in 30 seconds, those courtroom doors will open. And you know who's going to walk in? Barney Smith. That's what this case was all about, Barney Smith. And the allegation was that my client killed Barney Smith. Now you wait, in 30 seconds, Barney Smith's going to walk through those courtroom doors. He looks at his watch. The jurors are watching the door. He's looking at his watch. They're watching the door. He's looking at his watch. 30 seconds go on. He says, Barney Smith didn't come through that door, ladies and gentlemen. But you thought he might. And because you thought he might, because you believe that Barney Smith might walk through those doors, you have to acquit my client. You cannot, in good conscience, go home tonight and say you don't have a reasonable doubt. Anyway, the prosecutor makes his argument, her argument, they go away. The guy's convicted in 30 seconds. The judge says to the jury, and they typically do this, thank you for serving, collect your $5 on the way out. By the way, you heard Mr. Geist's argument about Barney Smith walking through the door and everything. He came back so quickly. It seemed to be very compelling. I thought you guys might find the defendant innocent. They said, well, we looked at the door, but we also looked at his client. He never looked at the door. So he knew. Get it? He knew that Barney wasn't walking through the door because he killed him. Nevertheless, you have to have beyond a reasonable doubt. In the criminal courts and in the civil courts, it's a preponderance of the evidence. And we talked about termination of parental rights. I mentioned it a little bit, and that's among your readings for this learning module. That's clear and convincing evidence. Now that's, if you've got reasonable doubt here, clear and convincing evidence is kind of here. I have my hand completely raised up. Clear and convincing is a little less than beyond a reasonable doubt, and then preponderance is about the middle. Well, it's at the bottom. That's the easiest standard of proof. Preponderance of the evidence. So those are burdens of proof. And they are what govern the prosecution of cases, whether it's a criminal prosecution or a civil prosecution. The burdens of proof are also important. And you can see, O.J. could be acquitted, and O.J. could be found responsible. Same witnesses, same kind of case, same dynamics, different standard of proof. Different standard of proof. Now, you read about the Redding's case, or the Redding story. That's in Professor Meyer's book right here. The Redding story. And that kind of gives you a walkthrough in the typical child abuse case, or child maltreatment case. Now, this one happens to involve sexual abuse, but the walkthrough involves the child finally discloses the secret that she's being sexually abused. And it's to her father. She says, my dad is molesting me. It's got to be a secret. I had a promise not to tell anybody. So the way things flow typically in the world of child maltreatment investigations is the kid makes a disclosure. Sometimes they tell a playmate. Sometimes they tell a counselor at school. Sometimes they might tell their mom or their aunt or someone. Once they make that disclosure, that person is mandated in New Jersey to report. By disclosure, I mean once they tell somebody that dad's molesting them or uncle's molesting them or grandpa beats them with a switch or whatever. Once abuse is disclosed, the person who hears that or has a suspicion about that abuse, whether it's disclosed or it's discovered, has to report that to the Division of Youth and Family Services immediately. So the typical timeline, the typical sequence for these cases is kid tells somebody, that somebody calls DIFUS. DIFUS, Child Protective Services in New Jersey, is obligated to call the police when it's a serious case. So we get most of our information from DIFUS. When I say we, the prosecutor's office where I work. But law enforcement throughout New Jersey gets most of their caseload from the Division of Youth and Family Services. So the kid tells, or the kid's discovered, that information is relayed to DIFUS. DIFUS relays it to the police, and an investigation is launched. We'll talk more about how investigations unfold and what those investigations look like. That's going to be very interesting. You will get a peek inside how law enforcement does its job, and I will take you right there from the child interview to the interrogation room to the interviews of the collateral witnesses. You're going to see a video about that, and I'll speak to it again, a PowerPoint presentation that I do as among your learning modules. In any event, law enforcement investigates. They interview the child, they interview the non-offending caregiver, the mother, they interview witnesses, they interview the person the child first told. We often call them the fresh complaint witness. That simply means the person that the child told, the person that the child unburdened themselves to, the person that the child gave this information to that led to the authorities eventually. It could be the guidance counselor, it could be their mother, it could be their aunt, it could be a playmate. We call that person who the child confides in the fresh complaint. Eventually, like I said, that information gets to the police. We interview that fresh complaint, the kid, the non-offending parent, the mother, the suspect, maybe some teachers, whoever's relevant. You do a thorough investigation, and then you make a decision about whether you're going to file charges or not. In order to file charges in New Jersey, you have to have probable cause. Whoa, we just heard that word a little while ago. Well, it's the same concept. In order to arrest somebody, you need to be convinced a little bit more than probable. More probable than not. He probably did it. That doesn't mean he did do it. That doesn't mean he did it beyond a reasonable doubt. It simply means that he probably did it. That there's an articulable basis. There's evidence you could point to that can demonstrate that the guy probably did it. Now, after that, there's a whole other process that has to unfold. When you charge somebody on what's called probable cause, okay, it is virtually the same as preponderance of the evidence that we talked about in the burden of proof comparison. The man is arrested. The next thing that happens procedurally is he has a couple of hearings. He's notified about his rights. There's something you may hear of called an arraignment. An arraignment is just a meeting at the courthouse where the judge tells you what the charges are formally. You already know what the charges are because when you're arrested on probable cause, they give you a piece of paper. And that piece of paper has the charges in it. And you get to look at it. You get to take it home or take it to the jail cell that you're going to sit in. When you have the arraignment, sometimes within a day or two, the judge will formally tell you what the charges are. They will make sure that appropriate bail is set. They will make sure that you're notified of the conditions of bail. You're not to have any contact with the victim, for example. You have to surrender your travel documents, your passports. You're not allowed to travel outside the state. You may have to have drug testing. It all depends upon what the charges are. But that's the first time you meet up with the court. Okay? And that's your arraignment. There may be another pre-trial meeting or two, it all depends, but most of the time you get your arraignment and then the case is sent to the grand jury. Now the grand jury in New Jersey is neither grand nor really a jury. It is 23 people who listen to the police case and they decide whether the case ought to be scheduled for a formal trial. So that's a nice filter in the system to evaluate the government's case. So even though the police think there's enough evidence to put a guy in jail and to prosecute. The grand jury might think differently. They have to make an independent evaluation. Now, most of the time, the grand jury agrees with the prosecution. People have said disparagingly that the prosecutor can indict a ham sandwich. The suggestion being that the grand jury is the prosecutor's tool, that we prosecutors simply get them to rubber stamp or endorse whatever we say. And a lot of that is persuasive because the grand jury does not hear from the defendant or the accused. There's no lawyer for the defendant in the court. None of the defendant's witnesses are testified. In fact, the prosecutor doesn't have to even present the defendant's story. We only need to present our side of the story. If there's a witness who said he did it and a witness who says he didn't do it, we can simply present the witness who said he did it and not present or mention ever the witness that said he didn't do it. You say, well, that's unfair. Well, it's not unfair. It's fair because the purpose of this jury is to evaluate the evidence in the light that's most favorable to the government, in the light that makes it most likely that he did it, to look at the best evidence the government has. And if that's not persuasive, throw the case out. If you start bringing in witnesses that said he didn't do it and did it, there's no end. It becomes a regular jury then. There's going to be a trial about whether he did it in fact. The purpose of the grand jury is just to evaluate whether there was probable cause, whether there was enough evidence to bring him in, not to reconcile all of the conflicts, not to evaluate the DNA or the fingerprints and look at the whole case. That's going to happen. That's what a jury is for, not a grand jury. Grand jury is just another filter, another way to look at the evidence in an objective, arguably objective, neutral way. So you have to file a complaint on probable cause if you think a guy committed a crime. The judge has to agree with that, so that's a filter. Then, a few weeks or a few months later, you bring it to a grand jury. They evaluate the evidence, and they make a decision about whether they agree that there's enough evidence. If you get past that, then one day you'll have a trial in front of a Petit jury. P-E-T-I-T. Grand, big, Petit, little. Related to the word Petit. P-E-T-I-T, Petit jury. The Petit jury, the little jury, is more powerful, more important than the grand jury. The grand jury is simply there to evaluate the quality of the evidence. The grand jury has 23 people. 23 people. A simple majority rules. So if 13 grand jurors think that the guy molested the kid and 10 grand jurors think there's not enough evidence, the guy's charged. If 13 think there's not enough evidence and 10 people think there is enough evidence, the guy is not charged. When a grand jury returns charges, they call it a bill, like the guy's name, like our former president, Bill Clinton. It's a bill. That has to do more about a bill of attainder or a bill of indictment. A bill was a word like for document, a really important document, with a wax seal on it. If he's not charged, it's called a no bill. Bill if he's charged by a grand jury, not by the cops. That's not going to do with a bill. Grand jurors return a bill, or they choose to no bill. No bill. And therefore there's no charge. It's just a peculiar term that applies to grand jury action. If there's a bill, then the case is scheduled for a Petit jury trial. And the Petit jury will one day hear all the evidence. The people who saw stuff, the people on the defensive side, the people on the prosecution side, the experts, the scientists, whatever's in the case. We'll talk more about that later. But there will be a trial on the facts one day if the grand jury decides to bill or charge. Now, a Petit jury is made up of 12 people. Grand jury 23, Petit jury 12. Can someone tell me what the agreement must be in a Petit jury trial? In a grand jury, it's a simple majority. One more than half. What about a grand jury? Unanimous. Unanimous. Everyone has to agree. If 10 people agree and 2 people disagree, whatever the outcome is, and no amount of further deliberations will get them to agree, that's called, can someone tell me what they call that? A hung jury. A hung jury, and the judge declares what? A mistrial. Very good. A mistrial. Can you go to trial again on the same charges? Yes. Because there was no adjudication. Double jeopardy only applies when there's an acquittal. When 12 people say not guilty, that's the end of it. But if there's no final ruling, you can go over, you can do it again, and again, and again, and again. But, you know, after 2 or 3 mistrials, most prosecutors drop the charges. Because the writing is on the wall. But you need a unanimous verdict. And it's 12 jurors. I don't believe it has to be 12 under the United States. I think in Florida it's 6 or 9 at times, depending upon the offense. I'm not sure. I don't think 12 is a magic number, but maybe. I can only tell you New Jersey it's 12. And the jury selection process is designed to get 12 people who are unbiased, objective, and don't know anything about the case. Some people have jokingly said that jury selection is designed to find the 12 most ignorant people in the county who don't know anything about anything. Because if you know the slightest bit about what the case is about, or the science behind it, or the social dynamics of it, or the town in which it took place, or the block in which it occurred, or the people involved in the case, or the neighborhood where it happened, we don't want you. We don't want you. We don't want anybody who knows anything about anything. We only want people who know nothing. Usually 14 or 16. Why do you think we picked 16 or 14?
Just in case if one of the jurors in the original group is sick or sick.
Yeah, exactly. And it happens in nearly every case. Somebody gets sick, somebody gets in a car accident, somebody winds up falling asleep during the testimony. They got to go, and you replace them. And the longer the trial, the higher the stakes, the more people we put in the box. I've tried cases where we had 16 jurors because nobody wanted to go back in time if we had to because a juror couldn't make it. The process of questioning those jurors to decide whether they are fair or not is called voir dire. V-O-I-R. V like victory. O-I-R-D-I-R-E. I always thought that was Latin, but it's not. It's French. And I'm not sure what it means literally, but in the legal world, it means the act of questioning the jurors, the act of questioning the jurors about their background, their history, and their knowledge of the parties in the litigation, the voir dire. At least in this context. We use the term voir dire in a lot of different ways in the law, but when the jurors are being seated, we call that the voir dire. And the defense and the prosecution can knock off jurors that we don't like. We want to select jurors that we think are going to be fair and honest, and quite frankly, when the lawyers do it, we want to get rid of jurors that we think are going to favor the other side, and keep jurors we think are going to favor our position. The defense is going to do the opposite. Typically, there are 20 and 10 challenges. The defense gets 20 challenges for no reason. Simply go, please excuse juror number 7 with our thanks, Judge. Juror number 7, step down. Thank you for coming. See you later. You don't have to give a reason. They get 20, the defense, and the prosecutor gets 10. Why? I don't know. That's the way it is. It's not fair, but that's the way it goes. But if a juror goes, I have an issue with this case, Judge. Can I talk to you in chambers? Okay, we'll all go into chambers. You know, Judge, this is about a little girl who was sexually assaulted. When I was in college, a boy attacked me sexually. I wasn't raped, but he attacked me and fondled me. It was a big deal. And I had to go to the student government, testify there, or this and that. Well, do you think it'd be fair? I don't know if I could be fair. The defense or the prosecutor might say, Judge, I don't think they can be fair. They're saying they don't know if they can be fair. The judge goes, we're going to excuse you. Thank you for coming, though. That won't count to the 20 and 10, because that person is being excused because they couldn't be fair. That's not a free challenge. They call them preemptive. The 20 that the defense gets and the 20 the prosecutor gets are for no reason at all. We just don't like the fact that they have a funny hat, or they're carrying a book, or they're wearing gloves and it's 80 degrees out. Never trust people with particularly dark glasses. You need to see eyes. Don't like people with dark glasses indoors, especially in a jury pool. Oh, everybody's got their own idiosyncratic beliefs about what's a good juror, what isn't. People with the New York Times, people with the New York Post, whatever. But you can just say, thank you, please excuse. But the prosecutor's only got 10. Before you know it, there's none left. So you got to be judicious. You got to use them sparingly. The defense has got a lot more wiggle room. And they tend to use it more, though. You cannot challenge a juror because they're a woman or a Spanish guy. You cannot challenge based upon ethnicity, race, or gender. You can't say, well, you know, this is a kid. I don't want less women or more women. I want mostly men. I think if I have mostly men, I'll do good. In order to get mostly men, you need to strike women. So you can't strike women solely because they're women. With those strikes that you get for free, that you don't have to say why. Judge, please excuse jurors 5, 6, and 7. Miss Donna, Miss Jane, and Miss Daniela. You know, you don't have to say why, but if the next round I just brought 2 more women, the next round the judge said, can I see counsel at the bar, please? Go up, what's going on here? You only strike a woman. Well, I have to say why. Well, that one was reading the New York Post, that was reading the Times. Well, you got to pick it. Times or Post, though, so. You need to explain why, something other than gender or race or ethnic background. And usually there's a reason why. But if you're exclusively picking on one group, you're going to get exposed, and it's unfair and wrong, and that is not allowed. You need to be able to articulate why you're challenging jurors. And then you get 12 that will decide it, and maybe 14 in the box, 14 in the jury panel, and then the trial begins. Before there's a trial, the prosecutor opens, or the deputy attorney general opens to the judge, or in front of the jury, the prosecutor tells what she thinks the evidence is going to show. The defense, they tell their side. They don't tell their side. They tell, well, they give a response. What they typically do is wrap themselves in the flag. That's the way we describe it as prosecutors. They talk to the jury about the presumption of innocence, about the burden of proof. They should never give away anything about what their client might do or what might have actually happened. Because the burden is on the prosecutor to prove the whole case. And the prosecutor may put in a lousy case. You don't need to give the jury anything to think about their position. So what they'll typically say is, ladies and gentlemen, one of the great things about this country is, one of the things that protects you and I, and my client who sits there, Mr. Gerard Pasillo, one of the things that makes this country great is the presumption of innocence. Not every country has that. But we have it in America. And that means that Gerard Pasillo, who sits here, Jerry Pasillo, they'll put their arm around him, is presumed innocent. No matter how you feel about him, no matter what the prosecutor says in his opening statement, no matter what the witnesses say, throughout this trial, at every moment of this trial, Jerry Pasillo is presumed innocent. They don't have that in the Soviet Union. They didn't have that in England when we formed this country. Lots of places in this world don't have the presumption of innocence, but we have it in America. Because what applies to my client Jerry applies to you too. That means they can't be hauled out in the middle of the night and be accused of something and be convicted without evidence. You need to hear that evidence. And that evidence has to be brought to you by the prosecutor, not by me, It has to be brought to you by the prosecutor, and you have to be persuaded beyond a reasonable doubt. That's pretty hard to do, ladies and gentlemen, and I'm satisfied at the end of the case, you will not be convinced beyond a reasonable doubt. That's another of the great things about this country. They simply can't haul you off and put you in jail on weak evidence, on speculative evidence. You can't say to yourself, where there's smoke, there's fire. You can't say, I think he probably did it. You know, the prosecutor put on a good case. There's some things in there that make me think Jerry's guilty. That's not enough. You have to be convinced beyond a reasonable doubt. That's never going to happen here, ladies and gentlemen. It's not going to happen. And you have to, every time you go home during this trial, go home and say, Jerry Pasillo is innocent. That's the law. The judge will tell you. It's one of the things that makes this country great, is that we have the presumption of innocence and the burden of proof. It separates civil societies that live by the rule of law from all other societies. That's what makes you be able to go shopping at the mall on Christmas and nobody harass you. That's what makes you be able to drive wherever you want to in this country. That presumption of innocence, that burden of proof, that requirement that we prove this case beyond a reasonable doubt is part of the fabric of our country that allows us to live in liberty and freedom. To have no fear of a government that can haul us into a courtroom and put us in jail simply because the prosecutor said we did it. And they'll go on and on. That's the way it rolls. That's what happens. They talk about it. They don't say, listen, my client never would go downstairs where the little girl slept. He would stay upstairs all the time because that's where his TV was. You don't want to say that. Maybe they'll put on 20 witnesses that say you did go downstairs. Now you as an advocate represented a set of facts that were demonstrably false. And you're in a tough spot. And I've watched lawyers all over America on these court TV shows, and Casey Anthony and O.J. Simpson and all these trials in between, where these defense lawyers start talking about the facts. There are very few good defense lawyers I know that will ever mention the facts. They'll simply talk about what a great country this is and that the prosecutor has to prove the case. We, on the other hand, tell the story of the case. You know, and you like to tell it in a way that connects with that jury. That they're listening, they're engaged, and they're waiting for it to unfold. You look at them in the eyes and you talk about what happened. Now, you better be able to produce, too. If you say all this stuff's going to happen and the witnesses don't say that, then your credibility is on the line, and you will lose, and the person will be acquitted. So, opening statements, witnesses, and then closing statements. Then you comment on what you heard in court. Then the defense talks about what happened and what people said, as does the prosecutor. And then the jury deliberates, and they make a decision. And if it's a conviction, it goes on the appeal, like I told you about. If it's an acquittal, he can never be tried again. And that's pretty much the process as it moves forward. Any questions about that? Okay.